May I have permission to enter into the record 2 articles from Louisville papers, one the Courier Journal and one from the Louisville News?
Without objection.
Thank you.
Mr. Meredith, you worked for Governor Bevin?
Yes, Senator.
You were his lawyer?
I was one of the lawyers in the office, Senator.
Okay. Governor Bevin issued some controversial pardons, is that right?
He did, Senator.
The FBI investigated those pardons, did it not?
Yes, Senator, that's right.
Did the FBI file charges against Governor Bevin?
My understanding is they did not, Senator.
Okay. Did you advise Governor Bevin on any of those controversial pardons?
The only controversial pardon that that I advised him on was one for Mr. Irvin Edge, and I recommended that Mr. Edge not be pardoned.
And was he pardoned?
My understanding from reading news articles is that he was pardoned.
Okay, so the governor didn't take your advice?
Apparently not, Senator.
Okay. But you didn't have anything to do with any of the other controversial pardons?
No, Senator.
Okay. If the New York Times, Mr. Meredith, published an editorial, let's suppose it said, Senator Kennedy is a bad senator. We don't like him. We think he's an ignorant slut. And I called the New York Times, and I said, okay, I want to write a letter to the editor replying. Can the New York Times tell me no?
I believe that they could tell you no, Senator.
Well, what if I said, if they told me no, I said, okay, I want to buy a full-page ad that says John Kennedy's a good senator. He is not an ignorant slut. And they said no. Can they do that?
I think the First Amendment would allow them to exercise editorial discretion and control over the types of ads they want to sell.
You think it's purely a First Amendment case?
There could be. I mean, I think there are potentially other laws that could govern how they make their decisions to sell ads. But I think if they're making a decision about whether you can buy an ad that says Senator Kennedy's a good senator, I think I think the First Amendment would allow them to exercise.
Suppose I'm running for re-election after this editorial, and I go to my local television station and I say, I want to run a political ad. And they say no. The New York Times says you're an ignorant slut. We're not going to run your ad. Can they do that?
I think that's governed. That's governed by different laws pertaining to the airwaves, which are governed by federal statutes.
There's only one Constitution.
That's right.
How can a news organization deny me the right to reply to an editorial that denigrates me, but yet I have a right to run a television ad that says the New York Times is wrong?
I think as in order to have permission to use the airwaves, I think federal law requires TV stations to give equal time or equal opportunity to buy ads.
Why is that constitutional?
Well, it's constitutional because my understanding, at least, is that the federal government controls. The airwaves essentially are federal property that the federal government can regulate and authorize the use of.
Yeah, but the federal government has to abide by the First Amendment, doesn't it?
It does.
I don't know. Explain to me how the New York Times can say no to me wanting a right of reply, but a TV station can't prohibit me from replying.
Senator, my understanding of the law is that the airwaves would be a public resource that the federal government regulates.
You think they're a common carrier?
In a recent Senate Judiciary Committee hearing, Senator John Kennedy questioned judicial nominees on controversial pardons, First Amendment rights, media obligations, and the limits of federal versus local power. What began as a review of a governor's pardons quickly expanded into a wide-ranging debate on constitutional law, free speech, and zoning authority. Senator Kennedy first pressed nominee Chad Meredith about his past role under Kentucky Governor Matt Bevin. Bevin issued a series of controversial pardons, some of which drew federal scrutiny. Meredith explained that while the FBI investigated, no charges were filed. He emphasized that he personally recommended against one pardon, which the governor ultimately granted despite his advice. Kennedy confirmed that Meredith had no role in other controversial pardons. Kennedy then shifted focus, posing a First Amendment scenario. Suppose the New York Times published an editorial calling him an unfit senator. Could he demand a right of reply? Meredith responded that the newspaper could refuse both a letter to the editor and even a paid advertisement, citing editorial discretion protected under the First Amendment. Kennedy pressed the point, questioning why private newspapers can deny rebuttals while broadcasters face different rules. The exchange turned to federal regulation of airwaves. Meredith explained that broadcast television is treated differently because airwaves are considered public resources. Federal law requires stations to provide equal access to candidates for political ads. Kennedy pushed further, questioning how this system aligns with the First Amendment, while Meredith reiterated that government regulation of broadcast spectrum is distinct from private editorial decisions. Kennedy extended the line of questioning to common carriers. Using a TAN-DT as an example, he asked whether a phone company could deny him service based on negative press. After initial hesitation, Meredith conceded that carriers cannot discriminate in this way because they operate under common carrier rules, bound to provide service equally. Finally, Kennedy...
Carrier?
I don't know the law on this specifically, Senator. I don't know that the common carrier analysis would apply there. Perhaps it would. I don't
Well,
know.
suppose I have my cell phone service with AT&T, and I call AT&T, and I say I want to expand my cell phone service, and they say nope. We read that New York Times article. You can't do it. Can AT&T turn me down?
I think theoretically they probably could.
No. How? Why? What
Well,
basis?
Well, I take that back. You're right. They probably can't because it's the same thing.
Why?
They're using the airwaves as well.
They're a common carrier, right?
I think that analysis probably applies there. That's right.
Okay. Mr. Mercer, can Congress pass a law that says cities are no longer able to participate in zoning? We're going to take it over at the federal level because we don't have enough houses. Would that be constitutional?
Senator Kennedy, I don't believe it would be.
Why not?
I believe that's the sort of thing that the Constitution has, not given Congress the authority under Article 1 to do that, and in fact...
Why not? On what basis?
In our system of federalism, those things that are not set forth in the Constitution are reserved to the states, and zoning is one of those quintessential public health, safety, welfare matters that we reserve to local government to resolve. And so I don't believe it would be permissible.
Zoning fees. In the end, the exchanges underscored the enduring complexity of First Amendment protections, federalism, and the checks that courts must apply when power is exercised beyond constitutional bounds. If you enjoyed this breakdown, don't forget to like, comment, and also hit the subscriber button for more political showdown.